You're welcome back to the Key Points here on TV3 and 3FM. Now, it's been just past some 2 years since there was a public outcry over a 90% failure of students who tried to get into the law school. In 2020, there was some improvement, but for 2021, not so much. That's not the real problem, really. It's now emerging that out of the students who failed this year's exam, some 2,000 of them, a number of them are deemed not to have failed. Some 790 are deemed to have passed, but did not get into the law school. It also follows a publication of the scores after an RTI request was also put forward. Apparently, the rules of the exam had changed, and it was a decision that decided that you needed to get 50% on both papers in order to get into the Ghana Law School. Now, administrators of the exam are being accused of bad faith because it seemed the rules may have been changed to achieve a certain outcome. Now, NUGS is demanding the intervention of Parliament, whilst the students at the law school themselves are planning a demonstration. The director of the Ghana School of Law, Mr. Prempe Ek, in a statement, asked that the results be accepted in good faith and that those who are eligible will be considered for 2022. But really, is that the solution? It's the whole brouhaha about reform and legal education and providing improved access. Our guest this morning, to my immediate left, is the Honorable Joseph Kpemka, former Attorney General and former MP. Good morning, and thank you for joining us, sir.
Good morning.
Great.
Former Deputy Attorney General.
Former Deputy Attorney General, sorry, I beg your pardon. Yeah. And then also welcoming Wanda Victor Kuto, who is the SRC President for the Ghana School of Law. Good morning, and thank you for joining us.
Thank you.
All right. But first, let's hear some of the sentiments of the students. And they had a press conference during the week. Let's hear Julius Anthony.
The actions of the General Legal Counsel thus far betrays the fact that there is a deliberate attempt to shut the doors of legal education to some students regardless of the grades they have made. It brings the entire examination and its essence into disrepute and makes one wonder if the failure rates recorded in the past years are truly germane. We demand the following remedies from the General Legal Counsel. 1, the General Legal Counsel should, as a matter of urgency, take steps to include the 499 students they unjustifiably denied their hard-earned entry into the professional course in the pass list. We want to state emphatically that the number of students who passed the entrance exams for this year stands at 1,289 and not 790, as the General Legal Counsel earlier communicated. The General Legal Counsel must also revise its examination rules, especially regulations which force students to sign an undertaking not to demand for remarking of their exam scripts when they feel cheated. We are also calling on Parliament to treat this matter as an emergency and resume from their recess to exercise their oversight responsibilities by inviting the appropriate authorities to answer for this injustice. Parliament cannot, and I repeat, Parliament cannot continue to be on recess when the laws they make are being flagrantly disregarded and maliciously twisted by institutions which in ideal cases should be upholding the law and pursuing justice. We must say without any reservation that we are disappointed in Parliament for not nipping this law school menace in the bud by legislative means. And on the point of Parliament, I'd want to sound this caution to party communicators, political party actors, not to by any means politicize this conversation on the Ghana School of Law.
And that's Julius Anthony, one of the student leaders there, outlining their displeasure with the state of affairs. So let me start first with the Honorable Joseph Kpemka. So I'm sure you followed this, and certainly this is not new to you. And I'm sure as Deputy Attorney General, this was something that at the Attorney General's office would have been something you discussed. First, are you disappointed that 2 years down the line, we're still having this conversation?
Well, I thank you so much, Jifa. Thanks to my younger brother and then your cherished viewers for this opportunity once again. First, let me make this preliminary remark that I have had the opportunity of serving on the General Legal Council as Deputy Attorney General and nominee of the Minister for Justice and Attorney General. And I have made my inputs on this matter. But I ran some commentary a few days ago on another platform. And I made a statement that, look, it's unfortunate. All we do is that when this issue comes up yearly, we make all the noise. After a week or two, that's the end of it. We wait. It comes again the following year. We make noise. After a week or two, it goes. There are no concrete steps put in place to nip this in the bud once and for all as a nation. The conversation seemed to be one of a knee-jerk reaction, the release of results, rather than a long-term, lasting solution that ought to be found without delay in this particular matter. I have heard the students make their complaints. It is true. The majority of us, senior lawyers today, did not go through what they are going through. That's a fact. Probably because of numbers those days. I recall that when I finished my LLB program, and they published the results and I passed, I walked to the law school and filled the form and took my admission home. That was all that happened. There was nothing like entrance exam or interview or anything of the sort. That time, we had Legon only. I think Tech had just released their first batch of students, and then they came in. We pursued it. There was no noise at all. Everything was going well. Then the superintendent body over legal education decided to open it up by granting accreditation to qualified universities in Ghana and other tertiary institutions to run LLB programs. And so when that opportunity was given, quite a number of faculties sprang up across the country, blowing up the numbers to proportions that could not be accommodated by the Ghana School of Law. And therefore, it led us to a situation where we ought to, and must as a nation at that time, take a decision as to what could be done to accommodate the ever-increasing number of LLB holders. And I am all out for anything that will ensure quality, but not anything that will deny competent persons from pursuing law. It is true that one of the means of ensuring that you take a few out of the lot is through examination. That is true. But the exam rules itself must not conflict with law. Common sense, good conscience. Again, before any exam is conducted, any set of rules that ought to govern that exam ought to be published and made known to whoever is going to participate in that, so that you don't seek to complain after results have been released. I am making this point because I'm zeroing in on what the students are saying, namely that about 499 of them got over 50%. And I made this point again, that I know a very good friend who got 58%, but has not been offered admission. Reason is that there were sections in the exam, and that if you got 99% in one section and you got 40% in the other, when you strike an average, you are going to get say, about 65, but that person is not qualified. Why? Because the person did not meet the 50% mark in one of the sections. So they are not aggregating it. They are looking at the passed mark based on both sections. You must pass both sections, but not an aggregated pass. This particular communication that has come from the General Legal Counsel acting through the Director of the School of Law, were the students aware before they participated in the exam? And from the information I have, they were not. So if they were not aware, and this rule came up only after the release of the results, that would be a clear afterthought. And that will not be acceptable.
Let me come in at this point. You said there's been no action to deal with this in the last 2 years. I beg to differ. I know that guidelines were prescribed, that the General Legal Counsel takes steps to implement a path that ensures that by 2022, the examinations are eliminated. A certain roadmap was indicated that needed to be implemented as well by the Ghana School of Law, and that is to demonstrate processes for these exams and the like. There's a view that there's a view that these have been ignored by the powerful GLC and Board for Legal Education. And even students were required not to sign an undertaking that they would challenge the exams. They are still being made to sign that, contrary to a declaration by court. That doesn't demonstrate the upholding of the rights and responsibilities of people who are administering bodies, particularly for lawyers who are supposed to be upholding the rights of others.
Well, first of all, let me say that if you go to court to vindicate your rights and there's a pronouncement affirming whatever claims you are making, and then it is disobeyed by a person, there are processes to vindicate your rights again. So whoever took the matter to court, and the court made a definite pronouncement that giving an indication to people that you are not having the right to apply for remarking is unlawful, and the person continues to do it, then you invoke the appropriate legal remedies that are available to you. And they know what to do. Those who actually are parties to that know what to do. What I'm seeking to say, and I say this again forcefully, is that, look, admittedly, there are problems with legal education in Ghana. And we should not pretend as ostriches and bury our heads in the desert. There are challenges facing legal education in Ghana. I have no doubt about that in my mind. I say so because, Jifa, if you look at our system, if you have a systematic expansion in the award of LLB, and there are no concrete steps taken to allow for people to have access to professional training, but just exam to determine how many because of space available in the Ghana School of Law, the conversation can continue for 100 years. If nothing is done about that, I believe that we'll come back and say the same thing in the next 100 years. So I have heard, and I subscribe to that idea, and as I continue to say that we need to empower the majority of the faculties of law. I'm being careful because I don't want to say that all faculties of law should be allowed to run the professional course. And I say this because last year, as a member of General Legal Counsel, and I'm sure that the student there is aware, and my very good brother and friend is also aware, that there was a damning report released by a committee of the General Legal Counsel, presided over by Justice Jones Duche, that indicted a number of law faculties in Ghana.
Yes, I remember. It said some of them didn't have the requisite number of staff, they didn't have the requirements in terms of some of the qualifications required to teach certain courses, and even the facilities, the books, the libraries, and all that.
Fantastic. So it means, therefore, that such faculties will churn out half-baked persons, not, in my opinion, not ready to pursue the professional course. Okay. So if you give such a faculty an additional responsibility to train people professionally, they will fall foul.
Okay, so let me hold you there and let's welcome Martin Kpebu, who is a senior associate with Fuga & Co. Thank you very much, Mr. Kpebu, for joining us. He's also a public interest lawyer. Thanks for coming in.
Thank you. But I've moved from Fuga.
Oh, you've moved now. Okay. Right. I guess I have to get updated, so thank you for updating me. Yeah, let me ask you, and one day I will come to you. Let me ask you, would you say that the General Legal Counsel has suffered credibility issues? What about the board for legal? Because it was quite a surprise to find that had there not been an RTI request for the scores to be released, we wouldn't have known. In fact, individuals would have second-guessed themselves that they failed, they didn't do well, only to realize that, some 700 of them actually did pass, but there were other machinations that meant they couldn't get in.
Yes, definitely. As for suffering the credibility crisis, it goes without saying. It goes without saying, so I'm sure it's a lesson for them and for all of us. I'm sure the last time I knew the students, that is to say those who had about 50 and yet from the new ex post facto criteria that they introduced have been deemed to have failed, have petitioned the board of examinations. So I'm hoping that they will do the needful. Because
but will the board acquiesce? Because the truth of the matter is there's no procedure per se to challenge the marking. There's no procedure to determine that I'm entitled to a remarking. There's no timeline given that the remarking should be done within a certain timeline that allows me to join my colleagues and not be disadvantaged.
Yes, you are right. And that's the Ghana Cook case, this Attorney General and the General Legal Counsel. Yes, that's a High Court decided, Gifty Ejechu, right, that they should put in place a requisite procedures for the remarking and all that, and not ask the students to do any undertaking not to challenge the result. Yeah, it's quite embarrassing, but it's part of a development process. So now that they are coming under a lot of heat, I'm sure they will do the needful. The petition, as far as I understand, was presented a few days ago.
Yes.
So let's give at least a week. Then we'll see whether they want to do the needful, because it's quite embarrassing. As Honorable Penka indicated, it's shocking that that rule that a candidate must pass both section A and B was not introduced before they went into the exam. And for us as lawyers, it's quite, a bit tacky that we would, the best of lawyers in the country would sit and then introduce the rule after the exam. It doesn't look tidy at all. But, because the petition is before them, we would want to be a bit circumspect and expect that they do the needful, and then, they'll
But to be fair, though, should there be a judge in this whole matter? I know the petition has been presented to them because really they are the body. But I'm just wondering, should they be the one looking into a petition that is almost against them? Is there an alternative if there was somebody else to look into it? Because I just see all these entanglements. You have the Attorney General or the deputy, if so nominated, to be on the GLC. You have other people, members of Board of Legal Education. They have entanglements with the AG's department. It's so convoluted for me. I'm not sure there's a certain fairness that we will get.
It looks like in our constitutional architecture, almost all the institutions, when there's a problem, usually you would write to them first. It's normal that, and it's not only in Ghana, you look elsewhere around the world, when there's a problem, yes, you can go to court, but don't forget, the court takes a lot of time, and also sometimes, because to err is human, let's not assume, as I said, look, the best of the best sit on the General Legal Counsel, and yet this simple thing that, no, you can't make a rule after the event and ask that the rule should retrospectively affect the event. No, it's only so far in our constitution, it's only when it comes to public finances, the budget and those, that's where it's allowed that, okay, the president, the government can spend ahead and then later go to parliament for a budget appropriation bill to be passed to, make it legal.
That's obvious. There's an obvious reason for that.
Excellent. So beside that, it's not the norm to usually pass a rule after the event. It's not the norm. So I'm sure, I mean, they will look at it, because otherwise it will make them look very bad.
Okay,
yes.
Let me bring in Wanda Victor Koto, who is the SRC president at the Ghana School of Law. So for the students who passed, the 700 and something
90.
that have now realized that I actually did pass, but there's this
499, right?
499, yeah.
caveat.
499.
Caveat. What have they been telling you?
Okay. Thank you very much, and good morning to our cherished viewers. I must say that I want us to respectfully put this discussion in context. The issue now is not about remarking.
No.
The issue is not about remarking. The issue is that some students, per the SRC audit, we have here the raw scores of all the 2,824 candidates who sat for the exams on August 24th. And per the SRC audit, we've noticed that 499 candidates had 50 and above, and were not part of the first 790 list that was released as part of the pass list. I want to make this point clear, respectfully. Now, the issue now has to do with this notice which I have here, this notice. It is the effect of this notice that has brought about this discussion.
If you don't mind, just read the notice for us.
Okay. Candidates or applicants who obtain the minimum threshold mark of 50% each in the two sections for A and B, into brackets, Part A and Part B, of the exam are eligible to be considered for admission by the General Legal Council for the 2021-2022 academic year to pursue the professional law course. The decision of the General Legal Council in respect of the published results of the entrance examination is final. Please be informed accordingly. Kwesi Prempe Ek, Mr. Director of Legal Education. This
is there a date?
There's no date.
Okay.
Okay. Now, it's good you've asked whether there's a date or not. Because there's no date on this notice, and by virtue of the fact that the notice was published together with the second result, which was published on October 4th, we deem it that this notice was dated October 4th. Now, because the SRC is on the negotiation table with General Legal Council through the Director of Legal Education, I want to talk about something briefly about these two notices. And to be fair to the General Legal Council, we want to act in good faith, because even on Monday we are meeting them on this matter. Monday we are submitting the 499. The Director of Legal Education has asked us to submit the list, the SR, so we want to act in good faith. The explanation that we're giving was that last year, when we wrote the entrance exams, some of our colleagues got 38 in the objectives, that's section A, and paper B couldn't do very well. But because they got 12, they got the 50 marks and passed. And the General Legal Council took the view this year that, I mean, that shouldn't be the case, and that it should perform very well, both in the objective, at least 50%, and part 2, at least 50%. And I'm mindful to say that the General Legal Council is an administrative body set up under Act 32, the Legal Professions Act. So they have some powers to take certain decisions. Now, what is the issue now? It's not about whether or not the notice was appropriate. It is about the issue of fairness, the issue of prior notice. I have here the advert. On the May 14th, the advert published in Daily Graphic, May 14th. This advert was issued by the chairman of the Independent Examination Committee. On May 14th, the criteria, the eligibility criteria to be admitted to the Ghana School of Law was published. And this notice was not part. This notice talking about the threshold, however good the reason could be, was not part of what? Of the advertisement. So it means candidates did not know of this notice. And in law, there's something we call legitimate expectation. And indeed, it is one of the grounds for judicial review. And I must say that the General Legal Council, by virtue of being an administrative body, is amenable to either administrative review or judicial review. Now, if you come out with a notice that's not to cut off 499 students who are not aware, and if you look at our Universe YA case, the issue of prior notice is key, which is why the SRC has taken a position that because the students were not aware of this notice before the examination, they should be admitted, and that we see the notice as unfair to the student. We will come to the role of Parliament in all of this. Parliament has a role. We'll come to the role of Parliament, and I'm happy we have here the Honorable Kwanka. who was a member of the 7th Parliament, who passed the LI 2427, the Legal Professions and Post-Course Act. He was part of the 7th Parliament who passed that, who come to that. So I'm surprised some MPs are issuing press statements and all of that. But they passed that particular act.
They were part of that parliament.
Yes, yes. Look, and also there's also what we call the numbers game. This year I have here the budget that was submitted to Parliament. Let me show you. If you look at paragraph 1015 of the said budget that was sent to Parliament by the Finance Ministry, he said in 2021, the Ghana School of Law expects to conduct entrance examination for 2,200 applicants and admit 550 to the School of Law. Let me stop here. So it means that even the budget that was sent to Parliament,
they had already predetermined how many students would get in.
Right, 550. Now, my understanding was that the Constitutional and Legal Affairs Committee of Parliament appealed, and the numbers were increased to 800.
So that's how come we see the 700.
So on the face of it, it appears Parliament itself has tied the hands of the General Legal Council. Something that the blame has to go everywhere. You see, let's be very frank in this matter. So Parliament has approved that, look, this year admit about 800 students. So it appears, I'm not defending anybody, but it appears that on the face of it, the General Legal Council is working within a certain threshold. That's why I'm saying that Parliament must come out clear on this matter. Their position, the majority group in Parliament, the minority group in Parliament must come out clear in this matter.
Okay.
We come to the examination policy of the school.
So let me bring and touch on an issue you raised about the background to coming with the new rule about passing both papers. Isn't it fair that really, if you want to pursue the professional course, you're covering a certain range of subjects, you must demonstrate grounding in all of them. It does not serve the students to get 70% in one part and maybe 10% or 20% in another, and then you say you've passed. Because even for those of us who even wrote A-level, and it's not exactly the best example, but general paper was a paper that many of us would have failed. I remember I failed general paper at my time, partly because I was told I didn't do well. When I checked, I didn't do well in the logic part. I did well in the English and that other bit, but the philosophical and the logic part, I didn't do well. So I ended up feeling I had to write it again. Luckily, there was strike, so 1 year I was home. I took that to write the paper and pass and go to university. So maybe it's not for nothing that students need to know that you cannot concentrate on a particular area that you may be very good at and neglect the other paper, thinking that one will balance the other. Hence, maybe this is a position that we must take in good faith and not necessarily as a way to make it look like there was a certain outcome the GLC or the board or the Ghana Law School was looking for.
All of us prior notice.
Retrospectively.
The issue of prior notice is what we are all talking about, all three of us.
All of that.
Were they told that this is the rule before they went to write the exam?
But
If they were told,
I wasn't told the rule. I only got to know after.
We've moved on. That's why.
So one.
He's made his legitimate point about that, and I think that we ought to respect that.
Okay. Now, a point. Okay, go ahead. You wanted to make a point.
Yes, I was just trying to say that's what we've been saying all along. And I must say that when I'm making this point, I'm very careful. Because after my first interview, when the first result was, it was all over Twitter that the SRS president is defending the General Legal Council. But that was not the case. There's the need for one to be objective. Because at the end of the day, we go back to management to lobby. And even on Monday, we are going to submit the auditor list, the 499. So we must always act in good faith. So after the justification is key. And in fact, when it comes to the Ghana School of Law, if you take a course like criminal procedure, it is a continuation of criminal law, which is done at the faculty level. So your understanding of criminal law ought to be sound. If you are drafting a charge sheet and you want to write something about, let's say, defrauding by false pretense, your understanding of the Criminal Offences Act, Act 29, ought to be solid. So there's no doubt about the importance of the entrance exams. However, the regulations have to be, the prior notice has to be clear so that I know that, I have to prepare clearly for Session A and I must prepare for Session B. So that is why the SRC is saying that admit these 499 students because they were not told. And you see, there's something about time allocation. If I know that I have to pass both, in the exam hall, I will plan my time. I will spend equal time for Session A and spend equal time for Session B. But I'm not aware. I know that I only have to get 50%. So if I know I'm good in objectives, I'll focus on objective, get 38, and just going to write something small for section B and pass. Yeah. And when we talk about legitimate expectation, it has to do with the consistent practice and conduct and representation of a public body like the GLC to the public. So what has been a consistent practice? The consistent practice is that if you get 50% cumulatively, you have passed. That has been a consistent practice. So in 2019, 128 students, it was only 128 students out of over 1,007 were deemed to have passed, because those 128 were the only people who had the 50%. Somebody had 49.5. 49.5 and needed just 0.5 in 2019. The person was deemed to have failed because the person didn't get 50. So this has been, and last year, over 1,045 students. And we need to give credit to management for having innovation, the triple track system for the schools to run. So 1,045 students, including myself, were admitted last year because we had the 50% and above. Cumulatively, there was nothing like Section A, Section B. So if you are bringing a new rule, which is within the rights of the General Legal Council, right? Act 32, the Legal Professions Act confers powers on the General Legal Council. So they have the right to bring in rules like this, but it should be fair. Look at our university, give reasonable notice. The advert is here, there was nothing like that. And I must say, if you look at Article 296, it talks about how you exercise discretionary powers.
Wanda, yes. So let me bring you in. Can you address?
Wanda, I just wanted to draw his attention to something. See, we are talking to the public, and sometimes we have to be a little literal instead of being too legalistic. He's consistently talking about Awini versus Waik. The public will not understand what he's talking about. And they're listening. I know, they're listening to us. That's why we just have to let him understand that there are young people who are very exuberant and all that. Okay. So those things, you just try to find a way of explaining to them that there's a legal precedence that says A, B, C, D. Okay. And then we have to be guided by that. But if you keep saying Awini and Waik, there are people who are listening out there who don't even understand what you're talking about.
Okay. Let me bring in
thank you.
Mr. Kwebu. So he raised something about Parliament. Are those thoughts fair, that Parliament seemed to have already given a certain framework within which the Ghana School of Law would be operating, looking at the budget, looking at what Parliament had approved?
Now, I should indicate that that aspect of it is not something that I'd seen before coming in here. So subject to something that may happen, my initial thoughts, I can only offer initial thoughts on it. Yeah, so to the extent that at least it's shown the budget figures and all that, what generally does paragraph 1055, okay? Yes, what I would say is that, well, we all know, even though Parliament has sanctioned this, okay, but we all know that even in the budget, there's usually provision for contingency, extra, right? Yes, so once across the table, we've all made the point that that rule has come too late in the day, and the saving grace is that in every budget, there's provision for contingency. It means that when they do the needful, it can still be catered for. Yes, that's it. Let's be very, very clear. Every budget has provision for contingency. And then this rule that you should pass A and B has come too late. The horses have bolted, and we don't run affairs like that. That's how he's consistent. So Awuni versus Waik is a Supreme Court decision. Okay, there was an exam or practice in this certain secondary schools in Notre Dame. Then the school authorities sought to go into it. They didn't give a hearing and all that. So it's the leading case in administrative law. At least the last time I knew. I don't profess to be an expert in administrative law. But when you go to law school, the leading case. So you see, they talk about the reasonableness. It's talking like, yeah. So we've all accepted that under this constitution, you give the rules ahead of the game. The rules are laid out ahead of the game. I like how he's put out the advert. Yes, I have a soft copy of it here. I was going to show. So it's good he has the picture. So a layman looking at it simply would just say, oh, at the time the students went into the exam hall, the rules, did you put it here? You didn't. And you see how he made the point. And it's good for us to emphasize. Depending on the rules, then you know how to plan your time around the questions. Yes, it's very, very key. You see, the University of Ghana, you're taking exams, then they tell you question 1 is 40 marks, question 2 is 20. You see, so that's the effect of that thing. Question 1, 40. Question 2, 20. So when you are writing, you know where to spend most of your time. But if you don't do this and then after the horses have bolted, you now bring in a new rule. No, it doesn't. So, but as I've said, we'll be a bit circumspect. We'll wait.
Yes, Honorable
Benka. The reality is that I think they may not have the rules, but the reality, I have to be honest with you, is that they are hit with the impregnable barrier of space. That's all about it.
Infrastructure.
That's all about it. That's the reality. And they are, because of the inability to absorb many more students because of space, they have to come out with these rules. But we are saying that, yes, you are right to come out with the rules, but make the students aware ahead of time that these are the rules. Because you see, it is a fact that last year we got numbers that passed that have never happened in history. That's a fact.
More than 1,000.
More than 1,000 yes, them passed. That was a historical record that we've never actually had in this country. And this year, if you add the 499 to the 790 something, you're going to get up over 1,200 or so. You know. So question is, it will mean that for part 1 and part 2, you're going to have in excess of 2,000. Yeah. And the fundamental question is GIMPA, Tech, and then main campus.
There's
are they
UPSA.
able to? Yes, no. UPSA is not running.
I mean, okay, so
I'm talking of the professional.
The professional, course. Okay.
Will they be able to absorb that, or are they prepared to absorb 1,000 plus in addition to the 1,000 that we already have in the system? I think the answer is going to be a big no. Because having been a member of the General Legal Council, I can tell you that it's an emphatic no. And so there must be a way of getting the numbers that can actually go in there. But this will actually bring to mind what many people are advocating, including my very good friend and brother, Professor Asari.
About opening up the exam. Okay, just hold that thought there. We'll come to that. Right. Let's just take a quick break and we'll be right back. And you've been watching the Key Points. You can join us via text. You can send your text to 055-369-8789. You can also tweet at me at Beho Bampo and also at TV3 and also at 3FM 92.7. We take a break and we'll be right back with our guests. Yeah, welcome back. And we're talking about accessing legal education. And our guest in the studio, if you're just joining us, to my immediate left is the Honorable Joseph Pemka, former Deputy Attorney General and former MP. We also have Martin Kwebu, who is also a private legal practitioner, immediately after him. And then we have Wanda Victor Kuto, who is the SRC president for the Ghana School of Law. So let me come to you, Wanda, because apart from all this discussion about those trying to get in, there's the controversy about how the whole administration of education is done when you are in the law school. So I'm learning that there are quite some concerns that students have. For instance, if they fail 3 papers, they are deemed to have failed entirely. And I understand that the costs also involved. I understand you will pay, what, 15,000 cedis a year?
15,600, that's what we paid last time.
A semester?
For the academic year.
For the academic year, great. And then I understand remarking per paper costs, what, 1,500?
Yes, please.
cedis. And what really have you done as SRC president to try and address some of these, should I say, rules about administration in the school?
Thank you very much. And I must thank you for bringing out this topic, because this matter concerns current students of the Ghana School of Law. And I'm happy our Honorable Martin Kwebu is here. He's a former JCR president for Ikwafoho, and he knows how this politics plays on. The current students, they voted for me. So it's important that I address their key issues here. Respectfully, I must say that during the transitional period, we met with management, SRC, and then as executives elect. and the outgoing executive, we met with management, and they were clear with us that this particular examination policy, we have to go to Parliament. It's beyond them. They were clear with us.
On the 3 papers being filled, and you write everything again.
Yes, because there's a legislative backing. The LI 2427, the Professional and Post-Call Law Course Regulation 2020, and I'm also happy the former member of Parliament is here. It was passed in 2020 when he was in Parliament, the 7th Parliament. They passed this LI. You see,
so previously, you didn't have to rewrite the entire papers if you filled 3.
No, this LI amended the 2018 one.
Okay.
Yes, but prior to that, I'm not sure.
Okay.
But
there's always an old rule.
It's an old rule.
If you failed one, then you repeated, eh?
Okay.
Then this is 2. No, okay, 1. You could go ahead and read that.
If
Then
you
2.
failed 1, you went to the second year and rewrote that one. But if you failed 2, you repeated everything.
So now it's even
now
better.
You've improved it to 3.
Yes.
But you are still complaining.
Yes, the LI has increased it to 3.
So which is better?
Yes.
Having 2.
Yes, those days it was 2.
As SRC, we will petition Parliament. You see, because this matter is Parliament. They amend the law. We all know this. So we will petition Parliament. We are putting things together. About this year, about 350 candidates failed. When I say failed, it means they've repeated the academic year. Majority, our 700 have moved to part 2, save that some have 1 or 2 papers to rewrite as supplementary, which is fair. But for those who have repeated, we are looking at petitioning Parliament to amend the law going forward. So this is a long-term plan. And also, you see, there's a cost element. I'm happy you made mention of it. Some of our colleagues are waiting for the Ross course. So if you get 49, then you can decide to go for remarking. So that if you get 1 more mark, then you've passed, you may move to part 2, depending on whether you had failed 4 or 3. So there's a cost element, which is why the SRC have introduced the scholarship fund, the SRC scholarship fund. And it's a transparent process. You apply online by the SRC Ghana School of Law website, www.gslsrc.org. It's very transparent, and the application starts on Monday.
But is that a solution? Because if people apply for remarking, and I learned that it takes a certain time for the results to come, and sometimes you'll be disadvantaged because those who may have, the others would have written while you are waiting for the remarking. If you don't pass again, then you've lost out on both fronts.
No, my understanding of the remarking.
Do the results come before the next group that are supposed to write?
Yeah, the result will come, but the disadvantage is that you will not know whether you're in part 2 or in part 1.
Exactly.
You see, and that is natural. Because if you go for remarking, and you join part 2, you are hopeful that you pass the remarking. But if it comes and you failed, what happens? Will you now go back to part 1? I'm saying that before you go for remarking, always look at the raw score. If you get 49, then you know that when you go for remarking, the chances of you passing is high because you just need 1 mark to get 50. But if your raw score is, say, 20, the chances of...
Are you aware that in the past, just a minute,
yes,
in the past, somebody got below 40 and went for remarking and got 72?
Yes, there could be errors, yes. That's
72.
Okay, but Honorable Kwenka, isn't there something to be said about the timeline? When the remarking is done, the results should come out in good time. So the person knows whether they are going ahead or not.
Because some of them are in a dilemma. Whether they are going to sit in year 2 or year 1, they don't know which lecture to attend and all
which is why the SRs, we are pushing that by next week, the Ross course should be out. And when students go for remarking, within 2 weeks, in the start of the new academic calendar, we should get the remarking results. That will inform whether you are going to part 2 or part 1.
A 2-week timeline is appropriate for after requesting the remarking.
Yes, please.
Let me come to Mr. Kwebu. So, Mr. Kwebu, is there a practical solution to the issues he raises, or the solution is political? Because he says Parliament, they passed this legislation. Now it can't really be changed by the school because it means we have to revert to Parliament. What would be a solution that then doesn't disadvantage the students?
Oh, so definitely, one of the ways would be that if they agree to reverse, but even let's put it this way, you have to come out with a new LI, and usually it comes from the General Legal Council. So they would have to put it together and present to Parliament. You see, but remember that on the matter of this remarking and all that, the High Court even, there's a decision of the High Court saying that, look, please come out with the procedure for the remarking. And of course, key amongst the procedure and everything will be the timelines, because without the timelines, then it's not much useful. Yes, so I think that maybe if there are some things they are doing, it will help that they come out, issue a statement on all the steps they are taking in order to abide by the High Court decision about this remarking. It would help. Or maybe you can send reporters to the General Legal Counsel to ask them that, yes, sometimes help. You know, this matter just came. If I had enough time, I would have made inquiries, but there wasn't enough time. So usually, you know, the media, the fourth estate, you do such a good job. So send a reporter to the General Legal Counsel to ask them that, look, the High Court said, look, you must come out to the procedure for marking and all the remarking and fees and all that. What have you done so far? Then we can get some clarity.
One more thing on the papers. I learned that the paper that the students fail the most is accounting. And the concern now is that, is there a problem with the approach of teaching the subject that causes a lot of the students to fail that one subject in particular? I'm just wondering if that's something that needs to be looked at, because if you are doing a trend analysis and you identify a particular subject of problem, there should be steps to tackle it.
You're right. My brief comment on it is that since this matter came, I've said it on a number of platforms that let's see the examiner's report. What have the examiners said is the problem? What have they seen with the scripts? And so this also speaks in that direction. Until we get the examiner's report, it looks like we will not be able to make much sense of it.
Rather the opposite.
Yes.
At our time, that was the subject that almost everybody passed.
The accounting?
Yes.
Your time?
Yes. About 99% of the students passed it.
Your thoughts on the issues raised about
the
timelines for the remarking, providing a certain procedure that gives students at least a fair chance at moving to the next stage?
Yes,
Is it clothed in Parliament to solve this?
You see, he made a point, and my brother reiterated it. But let's not forget that LI's Parliament per se is not a drafting authority. They are drafted by the institution that is mandated so to do, and it is laid in Parliament. And if nothing is raised about it, then it is passed after 21 days. That's what happens. That's our practice. So definitely the General Legal Counsel that brought that to Parliament. But again, if you raise it, then a certain percentage, about 2/3, must reject it for it to be taken. Otherwise, after 21 days, it is deemed to have taken effect. That's what happens. And normally the institutions will come and meet the Committee on Constitutional, Legal and Parliamentary Affairs and justify the LI. You know, so for example, the issue of if you fail 3 subjects, you repeat. Initially, it was 2. So it went to Parliament after all the discussions and all that. Then they raised it to 3. So that is even a very good step over the previous system that existed when we were in the law school. So clearly, it is meant to check a lot of things. That you've written 6 papers, you failed 3, there's no need for you to move to second year. Repeat the course. And that is even, those days it was very funny, Martin? People could get 80%. A, another A, another A. And then you go and get 2 referrals and you repeat the entire program. Then somebody gets 5 Bs and he moves on. You know, that was it. So I think the basic thing was to prepare you to be all round, so that you don't become a specialist at that stage. Because remember that when you come out of the law school, you are not a specialist in any area. You are a general practitioner. You can then go for maybe your master's program to specialize in a particular area, and etc. Or in your practice, you can decide to specialize in a particular area. But as I said, I think all these rules are meant to ensure that you have a broad knowledge of the various facets of law before you are called to the bar. But I agree with Wanda that the General Legal Counsel will need to go by certain timelines. If you apply for remarking, it should be possible that within 2 weeks you should know your fate, so that if you are moving forward, you go and sit in year 2. If you are not moving forward, you're going to repeat, you go and sit in year 1. But while waiting for that results, if school resumes, what happens? Which class do you sit? You are in a dilemma. and it can easily confuse you. So I think that ought to be looked at immediately and remedied going forward.
I've heard that the Attorney General can push for changes, you know.
Yes.
Is that possible?
Yes.
Yes.
Why can't the Attorney General?
The Attorney General is a member of the General Legal Council.
Why can't he do that?
The Attorney General is a member of the General Legal Council. And you see, his points, when he pushes, can be, excuse me to say, if they have to debate it and vote, it can be rejected. No. I mean, the Attorney General must not necessarily lord it over the General Legal Council.
Do you know the one they want? Not to interrupt, so that because you sat on the council, then you can better address. They are looking at section 1, subsection 5, the one that says that the Attorney General can give directions to the council and the council should obey. So some are saying that with that stroke of a pen, the Attorney General should be able to tend to. So because you sat there.
That would be very interesting. Because you see, the General Legal Council is presided over by the Chief Justice. And then the chairperson is on the chair, and a member of the committee will direct the chairperson. That would be another issue for another day of debate. Because the Chief Justice is the one who presides. The Attorney General is an ordinary member. So the Attorney General, who is an ordinary member, now dictates to the chair what to do, and the chair ought to accept.
So let me read it a bit so that because you have practical.
But is that a realistic approach? Because the way you say it, the way I read it is, the Attorney General has cases before the Supreme Court. Let's face it. I mean, will you be directing the chairperson, the Chief Justice, then you go to the Supreme Court to go and fight your case there, and the other, complications that come with it. Yes, Mr. Kwebu.
That's the price. So because he sat there, he's seen it. So I want to defer, but let's just read out the section again. So the Honorable Penka, haven't sat there for all years, sees how it plays. It says, the council shall, in the performance of their functions, comply with any general directive given to them by the minister. So some, as I said, I'm still reflecting, I haven't taken a definite position, but some are saying that because of it. But you know, from what Honorable Peka is saying, the independence of the institution and all that. So it looks like this provision may not be able to. It's
not practical.
It will be reserved for certain things, but not.
But not in this instance. Yes, Wanda.
Wanda, before you come in, please, let me draw your attention to something. Martin, have you realized that there's something creeping into our democracy? I don't know whether you've observed it. I know as a very senior lawyer, you know it. Something interesting is happening because of this separation of powers thing. Something has started happening in Ghana. I don't know. First of all, when somebody wrote to Parliament recently, telling the Speaker to declare a seat vacant, the Speaker replied. Did you read the language? The Speaker was clear that these are two independent institutions and he cannot be directed by the other side to so act. You know what that is telling us? That each side is trying to assert some level of independence. So when you spoke about Parliament's oversight, there's a limit to what they can do because that also will be resisted by the judiciary, which presides over the General Legal Council. And I recall that some petitions were sent to Parliament and some directives were given by the Right Honorable Professor Mike Aaron Okwe when I was there. And when it came to the General Legal Council, it was the belief of the council, and for that matter, the Chief Justice, that this was an interference in the direct work of the judiciary, which is also asserting its independence. So, at the end of it all, nothing happened. So that is where I'm saying that if care is not taken, ego of institutions will drag us to a certain wall that we will not know where to pass. Egos. So all of us must look at practical ways of getting these things remedied. I've told you, this is a law. You have read quite eloquently to us. But the practical demonstration is going to hit a difficulty. How the Attorney General is going to direct a boss.
Well, in this instance, maybe there are other instances where we work. Wanda, you wanted to make a point. Go ahead.
Yes, please. Honorable made a very wonderful point about the system, the exam system. So this year, the failure rate for accounting, the failure rate was accounting and civil procedure. Now, the issue about the accounting, at the Ghana School of Law now, is there are two subjects that constitute one paper.
That's for the accounting?
Yes, LPM and accounting, you write it as one paper, but on different scripts.
Yes.
So I have a friend, by God's grace, she's passed to part 2, but was referred in this course. She's clear that LPM, she's sure that she'll get like about 80, but accounting was the problem. So we are appealing that if you take LPM and accounting as one paper, if somebody should get, let's say, 60 in LPM and 3 more in accounting, for that course, the person should have been deemed to be passed. You see, but now there's a situation that you have to pass LPM and accounting on the same strength before you can be deemed to have passed just one paper. So it's an appeal, you get it. And this is somebody who hasn't done accounting before. Some of us were lucky in SS, we did business. So we had that small accounting background. Some have done MBA before coming to the law school. So they have that accounting background. So to be fair, the LPM course, they should look at balancing it. So that if somebody does very well at LPM, the law practice, and that perform little in accounting, they should consider the person to have passed that particular paper. Now the issue about the other one, you see, we are taught on different campuses. And I must salute the late Mafosao, who was, laid to rest recently. He lectures civil procedure at the main campus. When you're at the main campus, the person is civil procedure, when the questions can be write short, briefly, you don't write too much. Other campuses to say you have to be detailed. So now, sometimes...
So it's difficult to determine what is requested.
And you don't know the lecturer that marks. So we are appealing that going forward, the examiner's report, as Honorable said, should be made public so that we students will know whether, okay, when it comes to civil procedure, because apart from the LPM, civil procedure, most students failed civil procedure. They've passed, but they've been referred in civil procedure. Some have been referred. So we should know that, okay, this is what is expected when you are writing civil procedure, so that it will not be dependent on the campus in which you are. So that if you're in Kumasi campus, you don't have a different view of what you are being expected in civil procedure. When you're at Green Hill, or when you're at main campus, we should have the same, we should all be on the same page. So that civil procedure, we know that, oh, they expect you to write just the salient point. Let me give an example. If they ask the question about caveat being filed, some will say, just go to the point. Some will also say, oh, first define what caveat is before you move to the main point. Some will say, no, you are wasting time, be direct. What is the point? So we should know what the examiners expect of us. So the marking scheme is key at this point. Thank you.
Let's read some of your messages, and then we'll take a break. And then when we come back, we will address the issue of a demonstration that the students are planning, and whether they should be having a demonstration on this at this time. This one from Francis Carter from Twitter. I like the spirited articulation of the issues by the SRC president. He's doing the Lord's work. I wish him well with his engagement on Monday with the management. This one says, I just can't believe our professional institutions like the Ghana School of Law are suffering from infrastructure deficits upon all the funds they get from the fines people pay at the courts. Well, I don't think they are related, but I'm sure Honorable Kpemka and Mr. Kpebu can explain. And that's from Jonas Kade on Twitter. This one from Comeback, Chris, is a question. So does the GLC believe in the principles of law? Certainly they do. And these are issues that are being discussed. And Nenebi Oforisaki writes, I think the GLC should eat humble pie to avoid such precedents. The only crime these students committed is that they were born in Ghana. This one from Prince Henry. For how long can we continue to blame students who write and fail entrance exams in Ghana? It's about time we also blame the leadership and the teachers who supervise these students and their exams. More than 50% of failures can't be laid at the doorstep of students. And let me take some of your text messages as well that have come on this. This one says, please, in terms of space, the Ghana School of Law makes money enough to rent additional facilities. They are renting GIMPA and KNUST, so nothing stops them from renting. Also, the Ghana School of Law is one public institution or education that takes the highest fees, 15,000 and over. So it's not a venture that they turn a loss. Again, education is a right. They don't have to deny the person who's passed exams. Ghana and most institutions need more lawyers for efficiency. The Minister of Justice said last year that they can even admit 1,500 students. Another message from A.U. Farouk in Tamale North. In fact, the controversy surrounding accessing legal education is making some of us uncomfortable. As it stands, my interest to apply to the Ghana School of Law is putting fear in me as well as panic because of the monopoly over there. And Prince Henry in Koforidua, why do we have a budget for 550 students and allow over 2,000 students to register for the examination? This clearly shows some kind of bias and injustice to the students before they start writing their exams. The leadership of the country are in charge, and this is just daylight extortion to our colleagues who apply to pursue law in our beloved country. And a final message from Isaka. The law school admitted over 1,500 applicants because it was, well, I think in that year it was what, more than 1,000, but not 1,500 applicants because it was an election year. But now elections are over, so they are pushed to get back to the usual situation. Very, very interesting perspective.
It's not a political body.
We'll come back, but let's just take a quick break and we'll be back on the final leg with our guests.